A wonderful good afternoon, Dr. Oliver Schoen to Munich. A very nice afternoon to the audience. Thank you very much for joining us today at this Oxford webinar that discusses updates on FRAND and standard essential patents from the Munich courts. The Munich courts have been very active in the area of FRAND and standard essential patents, and it is really a big privilege that Dr. Oliver Schoen, who has been a significant decision maker in many of these judgments, is here today to present and discuss the judgments, provide an outlook, obviously not discuss his own cases, but give a sense of flair of where we stand in Munich in comparison to the rest of the world. For those who don't know Dr. Oliver Schoen, he's presiding judge in the patents in Munich. I have also gotten to know him through his work in the Ministry of Justice. And he's also one of the few people who have also gotten experience in diplomacy and who have been posted in Japan, working and continuing the work with Japan, among others on patent issues. Oxford is an economic consultancy firm. We specialize on FRAND royalty rate determination and licensing rates for standard essential patents, but also non-standard essential patents. We have been up for nearly 14 years now. We are an offshoot from the University of Oxford, and we offer economic analysis on matters around IP. What I would also like to say is we have a conference coming up on the 13th of January of next year in Oxford, in one of the Oxford colleges, which will look at emerging new technology matters and FRAND and standard essential patents. And we would be very excited and happy if you would be joining us in Oxford. If you're interested, please send us an email to info@oxford.com. We will have a very distinct panel of judges, practitioners, and litigators and barristers in Oxford from the tech industry discussing hot issues in IP. So with so much introduction, I think it's time to give the floor to Dr. Schoen for his presentation. Thank you very much for joining us all today. I hope you have an entertaining and intellectually stimulating hour. Thank you.
Thank you, Oya. Thank you for inviting me to present some ideas on the stage. So we have this seminar in Oxford next month, so you asked me to do some advertisement, and that's why I'm happy to speak here. There were some developments lately in Munich, and I would like to comment on it. So we talk about the amicus curiae letter of the European Union delivered to a pending court case of the Court of Appeal. And in the same court case, the Court of Appeal did send a preliminary opinion. And so I would like to give some thoughts about these two topics. Concerning the first topic, the amicus curiae letter of the European Union, we have a very strong opinion. About the second point, there's still a lot to discuss and to develop. I want to give you some information first about our court. So in 2024, we have already got more incoming cases than in 2023. But generally speaking, the percentage of SEP cases is lower than in 2023, especially in the second half of the year. If a case would come in today, we can offer hearing dates in next year, October, still some dates remaining in September. And we expect that we can offer hearings in 2025 for cases that are incoming until February 2025. We thought about the reason why there's a decrease in SEP cases. So I think that there might be three different points. One point might be that there's a certain uncertainty about the understanding of the Court of Appeal concerning FRAND. A second reason might be the UPC, because like a lot of cases going now to UPC. And maybe a third reason is that there's a general decrease in SEP caseload, as far as what I've heard from talking with lawyers. This year, there's also a new development. We scheduled many hearings this year, but in a high amount of cases, there was a withdrawal of the lawsuit before we had a hearing. So we don't know, most probably because the parties found settlement. But as a result, the number of hearings we had in SEP cases is considerably lower than in 2023. So both developments are connected to this pending case, the Court of Appeal, with the number 6U382422. And there was this letter sent to this court case. It was also part of one decision that we made in September. And one day before the hearing, on 31st of October, the Court of Appeal sent a preliminary opinion to the parties to give some hints how they understand the requirements of ECJ concerning Huawei and ZTE. And as far as I know, this one hearing at the Court of Appeal got a lot of attention from SEP crowd, and it took like 7 hours. And there was an additional court order from the Court of Appeal dating on the 28th of November, directed to the parties, clarifying some issues that they mentioned in the hearing and in this preliminary opinion. So we had one hearing in September. The reasons were delivered in October. It was before the hearing of Court of Appeal, but after we have received the amicus curiae letter of European Commission, the case number 70141743. It should be published with Back Online soon. And in this case, we followed our usual examination scheme, but we added some parts in order to follow the requirements that were requested in the amicus curiae letter. It means that we still apply ECJ Huawei ZTE standard as shown in the two decisions of Federal Supreme Court in FRAND 1 and FRAND 2. But in addition, we also checked if the first and last offer of the plaintiff was FRAND. And we did calculations in order to say if these offers were FRAND or not, but this information is redacted due to secrecy orders. In fact, even in the past, we had a lot of decisions where we had to calculate in order to evaluate if the order of the plaintiff and of the defendant are FRAND, but all these decisions were redacted. So we see that the part, like the outside, does not know how we actually kind of calculate or how we handle FRAND offer, the question if there's a FRAND or not. So as far as we understand the Court of Appeal does not follow the ideas of the European Commission, but still this improved examination scheme might be important for future decisions because according to the Court of Appeal, it's necessary to evaluate FRAND in our cases. Before I talk about the preliminary opinion of the Court of Appeal, I'd like to mention that it's a preliminary opinion and that the parties still have time to give opinions and that there's a possibility that the Court of Appeal might change their opinion and even maybe reopen the hearing. In case the defendant pays securities, the court may also continue with another oral hearing to decide if the offer of the plaintiff was FRAND or not. I want to start with some general considerations in order to get closer to this preliminary opinion of the Court of Appeal. So all our judgments concerning FRAND are redacted, so outsiders do not know the cases and behaviors of the defendants in the case that we have decided. That's a big mistake, because sometimes it looks that we are always kind of giving injunctions, but actually parties do not know the really like the facts behind this decision, because the redacted parts are so wide. So if parties negotiate about a license, about a patent portfolio, there are several reasons that they cannot find a settlement. I would say like there are three different groups. The first group is that the licensor asks for too much money or requests unacceptable conditions. So it's a group of the unframed licensor. The second group is that the licensee does not want to pay anything, that's very rare, or does not want to pay a sufficient amount or requests unacceptable conditions. So normally parties argue about the price. So they argue if they have to pay a per unit fee or lump sum. In some cases, we see that the defendants do not want to accept the license package that's offered. So, for example, they offer a certain standard, but the defendant wants to include another standard as well. So that's why they cannot find a settlement. And the third group, it's kind of rare. It means that, for example, they cannot find a license because of strategic reasons. So, for example, the licensee has an interest to show to the market that he is not willing to take a license easily in order to show that they are no easy target, to avoid other patent holders to ask for licenses. So that's the third group, I would say. When you talk about securities in our past cases, it was a topic in almost all the cases that we had to decide. Because the question if a security is paid or not is one aspect in evaluation of willingness. And there were several questions. So one question that we always had to discuss is the amount of securities. So are securities have to be calculated based on the request of licensor or licensee? And here we got the first important information from the preliminary opinion from Court of Appeal. The licensee should be calculated on the money that the licensor asked for. And but there are still open questions. The first open question is if a security rate should be improved in order to cover interest rates. Because if you proceed with a system that the Court of Appeal like kind of introduced, it may take a long time until the plaintiff gets money. So like a considerable high amount of interest may come up. And okay, there are several points that might be complicated. For example, if you ask for a per unit license, how do you calculate like a security amount? Until now, it was not a topic how securities are paid. So I call it the quality of a security, because the Court of Appeal in its preliminary opinion stated very clearly that only a qualified security is a sufficient security. So it means that the plaintiff has a right to get the security amount if the case is going to win. So it means that the only reasons that give the defendant a right to get the security back is depending on the case. So it's nullification or non-infringement. And one topic that we have to discuss in future cases maybe, if the plaintiff has a right that the defendant also stretches the security amount to other pending cases or cases that come up in future. So to explain, in Germany, like infringement actions are normally pending on one patent. So one patent is one case. It means if after 5 years of proceeding, the Supreme Court nullifies a patent, all the effort that we spend in calculation like a FRAND rate would be irrelevant. And that's different from other countries like UK or America, where you go with a certain amount of patents into some infringement proceeding. So we believe that most probably a willing licensee should agree that a given security should be spread to other pending cases as well in order to give some security. And another point is, when do you pay a license? In past cases, we saw that the securities were paid shortly before we had an oral hearing or shortly before we had an oral hearing at a different court. And so we said that in this kind of late payment of securities, it's part of a holdout strategy. We saw cases where the Court of Appeal stayed preliminary enforcement of our decision because the licensee paid securities after a first instance judgment. And a question that we discussed beforehand is if this will happen in the future as well. Because if we understand the Court of Appeal right, if the defendant pays the security amount and we decide that the last offer of the plaintiff is FRAND, there will be an injunctive relief, even the security is paid. So it means when the security is submitted before we make a first instance decision and we decide it's FRAND, there's still a preliminary injunction. So if the old rules would apply that you can pay a security after first instance and judgment, you may have an advantage because you have an advantage if the Court of Appeal would stay the preliminary injunction just because of paying of security. But in our understanding is the understanding of the Court of Appeal as well, that now everybody who's handling SEP cases knows about the opinion of the Court of Appeal, that nowadays, in order to show willingness, you have to do it in the first instance case, and you cannot wait until a later point. So I hope I made myself clear. Sorry. And the next point I would like to mention as a general consideration is that we believe that FRAND is a range and there's no single FRAND rate. And it's based in general on the per unit price and the predicted number of units. And a FRAND settlement is a result of negotiations, and there are several options possible. And that's the reason why an expert cannot evaluate or set a FRAND rate. It's only possible to evaluate if an offer is inside a FRAND range. And we believe that experts, especially court-appointed experts, are not necessary to decide if an offer is FRAND or not. The FRAND rate depends on the parties and the time the license contract is signed. That is also the reason why we believe that an interest should be paid starting from a certain point. We discussed how to handle this, and we looked into German law. In other fields, especially in mortgage interests, it's usually if you pay like a mortgage, there's always like a certain rate included to like cover additional costs like interests, like Grundschuldzins or Hypothekenzins. So maybe we can use this system as well to decide about the amount of securities. So I like to mention some reasons to say why it's so difficult to decide a FRAND rate, like a FRAND price. For example, small companies may sign a contract with a higher unit price in order to avoid litigation costs. Bigger companies may get a better unit price because the amount is high and the licensor has an interest to get quick money. Also, first contracts may have better condition because it is necessary to establish a license practice, so it's a time aspect. And also, if you look at older contracts, you may have a rate that looks cheap or expensive. If the license contract had a variable component, for example, for future years, and the real development is different from prognosis. And we also believe that the average price of a unit should be considered in evaluation of this FRAND. So there are a lot of additional problems like fast release or extension options. And also very complicated if there's a mixed license contract or a cross license. It makes it very difficult to compare. Why did I mention all these topics? Because we think that the range of FRAND is very wide. And we also believe that a bigger company does not only compare with another big company, because the competition is based on products, not on companies. It means if you compare license contracts, you have to see that inside the shop, the product produced by a smaller company will be in the same line with the product produced by a bigger company. That's why a bigger company has no right to be only compared with another big company's license contract. So next point I'd like to mention is like how to evaluate a FRAND rate. And we believe that the best way is to use license contracts that the licensor has made with other parties. And as far as we understand, it's also an approach used at UK courts. It's important when you compare a license with another license, it should, like the comparable license, should not be made under the pressure of an injunction. And of course, recent license contracts are preferable because of the time aspects of license. And similar products would be also preferable, but it's not necessary. We do not believe in top-down approach because the quality of patents is very difficult to measure. And it's not possible to evaluate each patent in a standard. And we believe there are too many uncertainties. And so that's why a very weak arguments, I believe. If the licensor has shown facts to explain his offer, like license contracts, it's to the licensee that he can show his own contracts in order to show that the contracts that the licensor has provided are not reasonable or representative for the market. So who can evaluate a FRAND offer? We don't believe that court-appointed experts will do. Party experts might be useful, but are not necessary. As far as we see, for example, UK decision InterDigitals against Lenovo, after hearing a lot of experts, they based their decision on comparable licenses. So we believe comparable licenses are the way. It means the court can do if the parties provide enough facts. About securities, I would like to talk. I think it's a very weak point in the argumentation of the Court of Appeal. And in fact, I do not believe that in many cases securities will be paid. Because the problem is that the licensor cannot reinvest if he only gets the security. He does not get money. Money is paid very, very late. So that's a general problem with the patent system, that the patent holders invest and reinvest in the payback, the fruits, will come about 10 years later. If the Court of Appeals system would apply, it means that there's a further delay. And it's also very unbeneficial for the licensee, for the defendant, because they have to pay a security, like looks almost like a guarantee, and most probably this security has to be shown in accounting. And still, even if securities are paid and the court decides that the offer of the plaintiff is FRAND, there will be still an injunctive relief as far as we understood the Court of Appeal. I would like also shortly mention how we evaluate decisions from other courts. If the parties do deliver decisions from other courts, especially EU, UPC, UK, US, we are considering, but they are not binding for Germany, for the defendant, because of principle of territoriality. So, but in many cases, we have a case law in our chamber that if our defendant started a rate-setting procedure in another jurisdiction and there was a judgment, his obligation to pay a security changes to an obligation to pay at least the amount of money that he requested and got as the money to the plaintiff in our case, and maybe pay some additional security in order to cover additional interest. I think that this will also apply for an interim license. So now I would like to talk about this preliminary opinion of the Court of Appeal. It's an 11-page hint, so I will just summarize. So Court of Appeal says that they follow European Court of Justice in the way of the understanding of the Supreme Court in FRAND-1 and FRAND-2, but wants to give further explanation, which are based on the opinion of Kühnen in his book. And so they argue that the FRAND defense is in dolo agit objection. And what's very important, and it's different from European Commission's opinion, is that if one offer is not FRAND, another FRAND offer can be made. This is very important for us because we think that the defendant has to inform the plaintiff in a pending court case if he wants to pay a security in order to start like the proceedings that the Court of Appeal requested. And so we believe that the defendant who wants to pay security has to inform the plaintiff. The plaintiff has to decide if he wants to stick to his last offer or if he reduces the amount or gives some additional benefits in order to start evaluation of the court. Because this is the result of Court of Appeal's opinion that you can change your offer until it is FRAND. So until now, we had a 4-step evaluation of like this FRAND objection. First step, it's very interesting because the Court of Appeal said that it is sufficient as a notification of infringement if the plaintiff starts litigation without injunctive relief. So this was also one point that the that the European Commission made. And so we understand the Court of Appeal that there's no change to our understanding in the past. The second step is also a point that the European Commission mentions. And also on the second step, the Court of Appeal follows our understanding that we used in our past decisions. There are very low requirements concerning the notification of willingness. Third step, licensor has to make an offer. Court of Appeal said that it's possible to give different offers in order to kind of follow the run of negotiations. If there are two different offers, the defendant can choose which one he likes to take. That's right, because normally the defendant will take the best one for him. So most probably the one which is closest to like a FRAND scheme. So in our cases, if we have to evaluate if the offer of the plaintiff is FRAND, what will happen if we come to a conclusion that the offer of the plaintiff is not FRAND? So normally in like the way we handle cases, we do have an oral hearing and all the facts are presented before the oral hearing so that the court can evaluate all the reasons that they made. So most probably when the securities are paid, we should have enough time to evaluate if the offer of the plaintiff is FRAND or not. And it means in the oral hearing, we will give our preliminary opinion if it's FRAND or not FRAND. And the question is, at this moment, is the plaintiff able to change his offer even during the oral hearing in order to get FRAND? And we just discussed it shortly, and it's, of course, many arguments to come. But since the moment when we evaluate if it's FRAND or not is the end of oral hearing, it should be possible to bring new reasons inside the oral hearing. So, for example, if the plaintiff is offering a license for 4 years for a certain amount of money, he might be able to change in the oral hearing for the same amount of money for a 5 years contract, like a 5 years license, in order to convince the court that the new offer might be FRAND. And of course, if this would happen, the defendant would get some additional time to respond to that offer, maybe even like a reopening, like another hearing maybe. So, fourth step, normally the question of willingness is the main topics that we discuss in our court cases. The Court of Appeal gave almost no information about it. Because the Court of Appeal said one interesting sentence, I can say in German, Sicherheitsleistung ist eine Konkretisierung der Lizenzwilligkeit. That's an interesting point. So according to the Court of Appeal, if you're willing, you pay a security. That's what I understand from the Court of Appeal. The question that we discussed a lot in our chamber is why did the Supreme Court discuss the obligation to have negotiations in FRAND 1 and FRAND 2 because there were no securities? So if the opinion of the Court of Appeal would be very convincing, there's no reason that the Supreme Court discusses for like 10 pages about the obligations to do negotiations. So this is maybe we have to consider why did the Supreme Court did not see this important role of security, because in FRAND 2, in site number 77, they do mention the security. So they, of course, they had it in focus. Anyway, so if a security is deposited, we do have to evaluate if the offer is FRAND or not. As far as we understand, the parties of this case at the Court of Appeal were a little bit unclear, so they asked, and according to a second information of the Court of Appeal from 28th of November, they said If no securities are paid, there's no FRAND objection. If securities are paid, the court has to evaluate the offer of the plaintiff. And if the offer is FRAND, there is an injunctive relief, even though securities are paid. That's what they say pretty clearly. So what is the consequence for pending cases at our court? So if the defendant wants to pay securities or has paid securities, I think we think that the plaintiff needs a chance to reduce the offer or change the offer. That has to be examined by the court. So what we see in many cases that the parties have like a very big range. For example, 100 to 10 or 50 to 1, whatever. So, and they stick to this very small or very big number. And so, because maybe both parties know that they have to negotiate and they will meet somewhere. Maybe in the middle, maybe on the top level, maybe on the short, we don't know. But we believe that the plaintiff has to get a chance to decide which offer actually is checked by the court. So for pending cases, it means, because there are so many uncertainties, we will continue to evaluate willingness as we did before. But we will also check if the last offer of the plaintiff is, and then we have two checks. The first check is if the offer is not obviously unframed. Because if the offer is not unframed, it's totally unframed, it's obviously not good, there's no obligation to deposit the security number. And the second check would be that we will argue if the offer is framed or not. Another reason why we will have this added check protocol is we want to give some arguments if a security is paid after first instance judgment in order to stay the preliminary enforcement of our decision. If the security is paid, we have to check if the offer is framed before we do with the numbers that we do have. And we will also make clear that, for example, there's some times of uncertainty. So in order to make this kind of decision possible, the parties should provide to the court from the plaintiff's side license contracts with other licensees showing the payment, for example, lump sum, information if the license was made to avoid an injunction, and if so, in which country, and information to calculate the per unit price, and also numbers about the quantity of products or number of units. It would be also interesting to know the price structure of the products, if possible, and information about a possible past release. Also information about additional benefits, for example, some options. And if different standards are mixed, they should provide information to separate the price for each different standard. And if there are cross licenses, also information to evaluate the value of the cross license. For the defendant, they can provide licenses with other licensors in order to show that the plaintiff's licenses are not representative. If applicable, the licenses with own licensees, but the defendant should almost always bring information about number of units and maybe the price structure. Of course, it's possible to bring private expert opinion, not necessary. if the defendant is not willing to provide numbers and price structures, at least for the past, we would see it as a kind of indicator of unwillingness, because you have to work in order to provide all the necessary information to evaluate if there's FRAND or not. What is the influence for our proceeding? If the mentioned facts are provided in due time, I think there will be no change in our timeline. So there will be no longer period for like the oral hearing. So we will still be able to have one oral hearing within 1 year. For pending cases, there might be the chance to write an additional brief to the court after oral hearing if the facts concerning the calculation are presented late. But this only applies for upcoming cases where we have hearings in the next months. It's not likely that we will appoint court-appointed experts. And of course, there are a lot of interesting questions to follow concerning trade secrets. If we do, for example, decide if an offer is FRAND, can we do we have to redact this decision? Can we, for example, maybe we have to redact the lump sum, but maybe it's not necessary to redact the per unit price? I don't know, that's difficult. It's a topic we have to discuss. Also, the interest rate might be an interesting topic. How much interest do you have to pay from a certain moment? And on the other side, if the plaintiff's offer is unframed, there might be also damages to be paid to the other side because the securities do cost money, but we think this should be handled in a new case. So the conclusion that we have is that the Court of Appeal's opinion is very strict and formal about FRAND, and we believe it's a very patent holder friendly approach, because I mentioned the disadvantages of the securities. We believe that the disadvantages for the defendant's side are bigger than for the plaintiff's side. And so this might force the defendants more to find a settlement. But we will see. It's important to know that the Court of Appeal has not decided finally, so maybe there are some changes. And because of new developments, we will change our reasonings in upcoming decisions. And it's very important that the parties concentrate on the facts concerning comparable licenses. Until now, we see parties do write a lot, but it's almost always difficult to find the relevant facts in the very wide letters of parties. An interesting question might be also the connection between security payment, if any, and other pending cases. And of course, so in the future, I think the discussion of frankness of plaintiff's offer will be in the focus of our decisions, I believe. Thank you very much.
Dr. Schoen, this is a lot to take in. I will have to need some time, like many others, to even digest all of what you said. This was a highly condensed webinar. There's a lot that you have offered in terms of insights, which is extremely interesting and valuable. It is really a lot. There are also several questions here which have come up. I think from what I learned, FRAND is a range in Munich. Comparables are very important. Interest rates, how to reflect interest rates, and the matter of the securities, the Sicherheiten, and that if you're ready to put down the money for a security, you're basically illustrating already your willing licensee. This was my personal gist of what I have registered immediately, but you said so many valuable things. I may need to listen to it a second time to really get everything of what you said. Let me turn to what questions people have been asking. I do not see the slides. Okay, let me see. If a button is just Amal, okay, that's a shorter one. Sorry, like questions that go over 10 lines, people. I'm starting with the one which is a 2-liner. Please explain the role of third party like arbitrators or mediators in deciding FRAND license terms in SEP disputes, asks Amal Shrivastava.
Okay.
Meanwhile, I will read the 10-line long questions quietly so I can paraphrase them. If a patentee is just starting, another question on its licensing program and doesn't not yet have fairness, I know that's the chicken egg problem. If you're just starting off and you don't have the big bang comparable licensing rate, how do you demonstrate its program is FRAND, given your comment that the German courts do not believe in top-down? Let's go with a very long one also before we should. The very long question comes from my friend and colleague Eric Stasik. He's saying the East European Commission says that FRAND negotiations should not be conducted under the threat of an injunction, but the CJEU decision lays forth what the parties must for before the SEP holder may make application for an injunction. Is there not a fundamental difference between negotiating under the possibility of an injunction and negotiating under the time pressure of an injunction being granted by a court? Does not the European Commission refer to the latter? And if so, how do German courts reconcile the CJEU decision with the European Commission's concern? Jesus, Eric, that's a very complicated question. So basically you're saying the relationship between the European Commission and the CJEU's decision, fine, in terms of like if there's a fundamental difference between negotiating under the possibility.
Can I answer?
Yes, and
so it's
under
very
the
complicated.
time pressure of an injunction. Jesus, yeah.
So of course there I just had a few days to prepare for this kind of presentation. It's in English, so it limits me anyway. And so I think not so much has changed. That's what I like to see. I also see, of course, that the Court of Appeal accepts like starting an action without injunctive relief as an offer to make negotiations. So it means that according to the Court of Appeal, there should be enough time in this 1 year until the oral hearing when you start a case without asking for a preliminary injunction. I think that's a problem in the argument that the Court of Appeal provides. But I cannot give you an answer to this. So we see it, and for like us as a first instant court, it's important to provide predictable decisions. And as far as I know, we were predictable in the past. So now we do have a situation where the Court of Appeal comes up and they make a preliminary opinion. And this might change. So what I like to actually tell in this presentation today is that we will continue working as we did before, but we will add some additional points in order to kind of cover arguments that might come up in appeal proceedings. So that's actually the information that we say, because we think that there might be some changes coming to the opinion of the Court of Appeal, but I don't know. I know the presiding judge from Court of Appeal for 15 years, but we did not discuss anything else. So I'm just working with the preliminary opinion and the second opinion.
Mm-hmm. And I think some of our participants have wondered if you could provide some more information on FRAND royalty rate calculation. There was one question, and I'm paraphrasing here, about like determining the comparability of licensing agreements. The terminology unpacking has come to be established in terms of figuring out if it's a comparable rate or not. And then another question, or rather a concern, is around categorically dismissing the top-down approach. If I understood the question correctly, this may be looking at FRAND without
I can
the
answer
royalty stacking argument.
Mr. Rastimborski, because it's an easy question.
Okay.
So we will not start getting like Hinweisbeschluss, preliminary opinions in our proceedings. So we had Munich proceedings before, but we do not have a two-hearing process in Munich now. We have a one-hearing process. So we have normally 2 letters of each side. And according to our system, it is the defendant who has the right to write last. And we saw in several cases, when we do give a preliminary opinion in the first hearing, that it makes it worse because parties stick to this kind of opinion, and the case gets more complicated and maybe even some unbalance. So we really believe that all the lawyers highly qualified, they notice, like we publish our judgments, and so there's no need to give a hint. Only if there's an obvious missing part, we would give a very short notice. So that's the way we handle our cases. So normally, no reason to give any preliminary opinion in our hearings.
Okay.
And again, I told in different options several times, we have a very high caseload. So normally, in the 7th chamber at least, we prepare for the cases with writing a pre-judgment, votum in German. So it means that we normally come with a draft of a written judgment into the hearing. It does not mean that we have decided it all, but we just write down all the parts that we think it's necessary by extracting from the party's content. And we, in order to kind of finish the case quickly, we normally have like a Genugstermin. We announce our judgment 2 weeks after our hearing because we want to close the case as soon as possible in order to have a capacity to handle the next cases, and this will not change. So all these additional arguments that should be provided to the court, we will handle in our regular routine like we did before. But we like the parties to provide this information that I mentioned before in a more clear and more structured way than the parties provided it in the past. That's actually what we want to see.
You're seeing the question yourself, Dr. Schoen.
Okay.
Maybe you pick the questions you like to answer rather than me pre-reading them.
About mediation. So we have like mediation in our court, and we are very willing to send any party to mediation. I know that Dr. Fricke, head of 44th chamber, even mediated in SEP cases a few months ago, very successfully. People were very happy. So normally, we do not ask parties in an SEP case if they want to do court mediation, because we believe if there are like 20 lawyers on each side or 10, it does not sound very likely that they will start mediation because the court is mentioning it. But this option applies. And normally, I would say it's more like a service for small and medium-sized companies. But Dr. Fricke told me it was very successful, even with SEP parties. And in past cases, when we discussed willingness, there was an argument that in some cases the plaintiff agreed to give the rate setting to like an arbitration court. And we think that this is showing that the plaintiff is willing to get a license, because by sending it to an arbitration, the plaintiff kind of loses the right to finally decide if the settled rate is FRAND or not. Same would apply for the defendant side if this offer comes in an early stage. But what we do see, that the offer to go to an arbitration means binding effect. It's a different mediation, not binding, arbitration binding. That the offer to go to an arbitrator normally comes on a very late stage, just maybe 1 month or 2 months before the oral hearing. So, and we say this is kind of hold-out strategy in past cases, depending on this on the case. So it's not a general rule, but we evaluate the case with all the different aspects.
There's 11 other questions. There's a question around injunctions, from what I see, the proportionality of injunctions. There's a question about the calculations, the unpacking. There's also a question about transparency and getting more and better insights into.
Oh yeah, I don't know. It's on 5 o'clock. Do we discuss this kind of topics in Oxford in next month? So maybe we can continue there.
Yes, you are the judge. I follow. You tell me what you want. We can go over. We can finalize. But I think it really, like, you had very little time to prepare. I must admit it, because I was so insanely busy with the conference. So I think we gave the audience a very good first flavor, really, in terms of the directions and insights from Munich. And we really invite everybody to join us on January 13 in Oxford. If you have time, we're already starting on Sunday with a side program, and we are trying to present also Oxford as a place to visit. We are expecting colleagues from the UK government, from Dr. Klaus Kabinski from the Unified Patent Court will be joining us. Sir Marcus Smith from the High Court in England and Wales will be here. I hope I'm not forgetting everybody. Obviously, Dr. Schoen will be contributing again. We have lots of people from business, from the ICT sector, so no life sciences people will be expected in Oxford. But from telecom, blockchain, quantum, AI, semiconductor, ICT, tech industry, generally speaking, we expect a lot of lawyers, a lot of solicitors, a lot of in-house people to debate also the relationship between the UK and Europe, I hope, to come to a first beginning of coming closer to each other. And please, if you're interested, please do get in touch. Everything is so far on the website oxfuse.com. So not Ox first, but on the Oxfuse website, like Fuse, like opinions, perspectives. Otherwise, send us please an email to info@oxfirst.com. We're just before the Christmas holidays, and I know it's a very tight timeline, but we really hope you can make it. We'll have in-depth discussions in Oxford on all of these topics, and we would welcome your contribution and participation. And I'd like to thank you all for so quickly reacting to this webinar, which was just announced last week, I think. And we still got 200 people to register. I think paying ample testimony to the importance of the decisions and contributions made from Munich and its judges. With all of that being said, have a lovely beginning of the week. Thank you all very much for joining. Thank you very much, Dr. Oliver Schoen, for presenting here today. I thought your talk was very concentrated and full of interesting insights. I will need some personal time to digest all the things that you have said, really. Yeah, thank you all very, very much. Have a lovely afternoon, and please join us in Oxford, January 13, 2025. Okay, bye-bye. Thank you very much. Bye.
Bye.